email just in case you have any questions. Feel free, and I'll share it again at the end. If you have any questions, you can always contact me. A short disclaimer is that everything that we discussed today is opinion. I cannot provide, these are very complicated rules and regulations, and I cannot provide any legal advice through this presentation. We are not dispensing legal advice, obviously, and by listening to me today, it doesn't establish a attorney-client relationship. So let's jump into a short regulatory history of what's been happening with the information blocking rule. So the ONC introduced the information blocking rule back in May of 2020. And then the rule went into effect in June of the same year, and it was supposed to have a compliance deadline of November 2nd, 2020. However, because compliance was difficult, on November 4th, they had another interim final rule, and they extended the effective date to April 5th of this year. So it's been about a month and a half that this rule has been in effect. So what is information blocking? Information blocking is simply when an actor interferes with the access, exchange, or use of electronic health information. And there are some exceptions and some by rulemaking and by statute that apply to this process. We're going to break down first all the vocabulary in this statute, so you understand what it means to be an actor, what it means to be an interferer, and then we're going to talk about the exceptions. So the way that the statute is written, it talks about an actor. You have to have electronic health information, has to be involved. There has to be an interference with the access, exchange, or use of the EHI. You have to have an intent to block this information, and we'll talk about the levels of intent. There has to be, and it's not, and there are exceptions that you can use to block information, and then also all of this information, all of this blocking can happen if it's required by law. So generally, information blocking doesn't really change how users or what users can access or not access. It talks about how users can access it, and it sort of wants to prevent the people who own or have possession of the information from blocking it to get to the next person or to the user or to whoever owns it or wants to implement or access it. Okay, so let's talk about individual one of these, the vocabulary that's in the act. So there has to be an engagement in the practice, and that means both an act or an omission of the act. So just by not doing something, you may be blocking information. So they contemplated that doing or not doing something that would cause a block of flow of information would be considered engagement in the practice of information blocking. Now, interference with access, exchange, or use is based on a reasonableness criteria, and it says there's a reasonably foreseeable risk that your behavior, the act or the omission, would prevent or materially discourage or otherwise inhibit access, exchange, or use of electronic health information. What is access? Access means what is the ability or means necessary to make electronic health information available to a user. Exchange means transmission of the information from one user to another user, from one platform to another platform for a purpose. And use is what you can do when you access the information afterwards to implement an action based on the information that you receive. So that generally covers most of the vocabulary. Electronic health information, the vocabulary is a little bit different from what is used in the HIPAA rule. HIPAA rule talks about electronic protected health information. In this scenario, or in this case, electronic health information is basically all the electronic protected health information that we know and understand from the HIPAA rule. that is in a designated record set. And what is a designated record set? We know that anything that you use to any record of the patient that you use to make decisions about the patient is considered a designated health record set. Now, specifically, electronic health information does not include any psychotherapy notes, same as HIPAA. It doesn't include the information, provision of information, or exclusion is allowed. You're allowed to exclude psychotherapy notes. So electronic health information does not include psychotherapy notes. It doesn't include de-identified data that doesn't have any protected health information attached to it, like address, name, medical records, zip code, and all that. And information compiled in reasonable anticipation of any legal proceeding. So if you have documentation that you're compiling to defend yourself in a legal lawsuit, that is not considered electronic health. In terms of actors, the statute defines the actors in three categories. One is the healthcare providers for you. The other group are people or institutions, individual or institutions who are considered health information networks or information exchangers. And that can be any individual or entity that has the ability to exchange or cause an exchange of an information from one location to another location. And that could include healthcare providers, depending on how they're transmitting information, health IT developers and certified health IT guys. Those are groups. Those are the groups of people who are developing information technology systems. So those are the three main categories. And the reason the categories are important is because the level of intent applicable to each category becomes important. If you're a health IT developer, the intent criteria includes knowing and should have known about a system that would, for example, cause information blocking. Whereas for healthcare providers, you must really know. There's no requirement that you should have known and you should have prevented it. So as long as you can show that you didn't know, that means you didn't have the required intent to cause an information blocking. So those are the different requisite intents for the different types of actor. They kind of gave a little bit of a break to healthcare providers in order for in terms of the intent that the government has to prove for bringing one of these cases against an information blocker person or institution. So here are a few examples, about 6 of them. I'm going to talk about a couple that kind of gives you an idea of what information blocking would kind of look like. So if you have internal policies that are more restrictive than regulations, right? So you have internal policies that says, you really require written consent before any of the patient's electronic health record with unaffiliated providers for treatment purposes. You'll know that under HIPAA provisions, you don't really need authorization to disclose information for treatment purposes. Misunderstanding of the law, if you misunderstand HIPAA rule and you have incorrectly implement more stringent requirement on the exchange of information. If you engineer difficult electronic health information flow, let's say hospitals, they have these electronic health records that are too complicated and it kind of stops the flow of information through the system, that would be considered electronic information blocking. This is some unnecessary delays is something that could happen in a healthcare practice where a healthcare provider has a policy that I'm not going to disclose information that comes to me, let's say the labs that I receive, until I review it before I give it to the patient. So, and then you don't review it for several days. So that is an unnecessary delay because the patients must receive that information pretty quickly. And those are the other ones are, discriminating against electronic health information vendors going with one that is more restringent, stricter than the other one, that as an example. So those are some about a few examples that you can look at it to kind of give you an idea of what information blocking entails. These are some of the practices that are not considered information blocking. So if the statute requires you then not to provide that information, for example, I don't know, psychotherapy notes, for example, is an exception that you don't have to provide those documentations to the patients, then you can not provide it. And there are 8 exceptions that we're going to go into after this. So again, with the psychotherapist, for psychotherapists, any of the psychotherapists who keep electronic health information, the information blocking rules apply to them. And those therapists who work for larger organizations and use electronic health records that has a capability of immediately providing information to patients, they have to instantly make that access available. If they work in large health systems, they should also provide immediate access to the patients, because those larger organizations have that capability. And if you keep EHI, but you do not have a electronic health record that allows for direct, immediate patient access, then you can say that it's infeasible. That's one of the exceptions, infeasibility, that we're going to talk about. You can claim that it's infeasible for you to provide instant access, so you're going to have to make some delays before you provide that information. But that's how generally it applies. In terms of exclusion, what notes are excluded, it's pretty much similar to what HIPAA law allows. So psychotherapy notes that are written separately and kept separately and do not include diagnosis, symptoms, functional tests, medical prescriptions, and treatment, anything that has to do with the patient diagnosis and wellness management, treatment, are protectable, but they have to be kept separately and not include any of this documentation. So psychotherapists who use an uncertified electronic health record, such as SciBooks, they're not required to follow the open notes rule, which is, and they can claim infeasibility exception. It's just more difficult for them to switch electronic health record. They should talk to their EHR vendors to see whether they're going to be compliant, and if they're not, they can just say the reason for delay or not production is because it's infeasible for them under the circumstances, and basically because of the electronic health record that they're using, it's not possible to provide those records immediately. All right, so let's talk about the 8 exceptions. There are 2 categories. One has 5 exceptions and one has 3. The first one involves not being able to fulfill a request. The second category involves the procedures that kind of interfere with fulfilling requests. We'll go through each one of them. So the first category, 5 of them, are when there is you cannot fulfill a request to access, exchange, or use EHI. So the first exception is, and I'm sorry, these slides are a little bit, it has too much information in there, but I think it's necessary that you see everything that applies to these exceptions. These exceptions are very complicated, and we're going to breeze through them, but at least it gives you some guidance if you want to go back and kind of understand what it's about. So preventing harm exception is really exactly what it is. So there's under certain circumstances, you as a healthcare provider, you do not want to provide information or disseminate information or patient information because you think it will cause harm. So you can use this exception and document this exception to make sure that you're not blocking the information and you have a reason to keep it to yourself. For example, in a domestic abuse records and notes, if you think that those records can be viewed by the abused abuser, then you can document it and say, we are not releasing this information because we think that there's a to prevent harm. But in order to do that, you have to understand, you have to document the type of risk. Is it imminent? Is it low? Is it high, medium? The type of harm, is it physical, emotional? And then the implementation basis of how you kept the information. And you should always err on the side of providing all the information that you can and not providing the information that you want to keep. So if there's a way to separate domestic abuse records from the rest of the medical records, you should provide the other rest of the medical records and keep the abuse records. If the abuse records is integrated into the health, the patient's records, then you can use prevent harm and also infeasibility exception, saying that I couldn't really separate those two from one another, and make sure that you document this, pretty well in terms of why. And for healthcare providers and professionals who see these type of patients, they have adolescent patients, they have domestic abuse patients, it'd be a good idea to sort of have a policy in place or revise or review your policies to make sure that you are your staff knows how to review these documents and how to document these type of exceptions for those specific cases. The other one is for privacy exception. So one of the four, when you're blocking information for privacy purposes, one of these four categories must apply. So for example, if the precondition not met, not satisfied, requires you to get consent or authorization to release information of a patient to, let's say, a family member. That's not related to PTO. So that means payment, treatment, and organization, right? So if there's an authorization requirement, that would have to be satisfied before you produce it. If it's not satisfied, then you can rely on this exception that, hey, I never received the authorization. I use the exception of privacy, and once we receive it, we can disseminate it. Let's say, for example, number 3, this code specifically relates to the standard of access to protected health information, right of access. Again, psychotherapy notes is one example of right of access. If it's psychotherapy notes, then you can hold it for privacy purposes and cite to this privacy record. You gotta make sure that in documenting this and implementing a privacy exception, you tailor your response as much as possible. So you produce as much as you can, but anything that you can hold, like in psychotherapy notes, for example, you can release the medical records, but keep the psychotherapy notes. So that the privacy would apply only to that tailored response that you have. You got to make sure that you apply this consistently. If you're requiring consent and authorization for precondition not satisfied portion, for example, make sure that you always require that from everyone. You don't waive that criteria for someone that you know and they call you on the phone, but then you require it from someone else that you really don't know on the phone. Everybody should be treated the same and everybody should provide the authorization. Have some written policies that explains this for your staff, and then just make sure that you take reasonable efforts to make the documentation if you're using any of these privacy exceptions, any of these exceptions. Security exception is one that is another thing that's very similar to privacy, but for example, under a security exception, it could be that the law doesn't really require it, but in order for you to safeguard the confidentiality, you will require an extra step. Let's say somebody calls you on the phone and says, I want my medical records. You don't really know if that person really is who she is. Therefore, you can ask them for security purposes to provide some information that you can qualify their identity, and that's perfectly fine. You can say, I don't want to give you that information until I satisfy my duty in terms of identifying you as a person that who you are. So that would be a security exception that you can implement and you can rely on in that situation. Now, infeasibility exception is one that I think would be used by healthcare professionals very often. There's many times that there's uncontrolled events, segmentation, infeasible under circumstances. These are all different criteria that could come up that you are going to say, hey, it's not possible for me to provide this information. For example, an example of segmentation, that you as an actor, you cannot fulfill the request is when your substance abuse notes are intermingled with the electronic health records, and you're unable to separate them so that the Part B program records, the substance abuse records, are not provided to or disseminated or transmitted. In that case, you can say, it's infeasible for me to separate this information. I cannot provide you that information. And you have about 10 days to respond to that infeasible blocking or blocking due to infeasibility. So just remember that if you want to rely on one of these, on the infeasibility exception, you have about 10 days to make this response. And then the final one is healthcare IT performance exception. So if something's coming up, you're fixing your IT system and the system is down, obviously you are allowed to have maintenance done on your system. But as long as it's not taking long, it only takes as long as it's necessary. It's not taking too much time, and you meet the requirements of that is set out in the code, then you should be okay. You can rely on IT performance exceptions, say that my IT is down, we're working on it diligently, and these are the documentation, and sort of rely on this exception. So there's a point here, it says if the unavailability is in response to a risk of harm or security risk, the actor must only comply with the preventing harm or security exception as applicable. So, you can rely on this if it's a harm or security exception. You can rely on this when it's related to IT performance exceptions. All right, so now we have exceptions that involve the procedure that you use to fulfill requests, and these are generally applicable to entities or businesses, and it allows businesses to ask and negotiate for licenses. Let's say it's a vendor that wants to, you want to access the vendor, they require you, and you have electronic health records on it, and they require you to buy a license, and this is an exception that would allow them to negotiate a license with you. It has some time regulation. In 10 days they have to respond to you, 30 days they have to kind of come negotiate the license. They can't discriminate, the royalty has to be reasonable, so on and so forth. So that's the licensing exception. The fee exception is similar. It's about charging a fee for the services that they provide in order to provide, let's say, access to electronic health records. Vendors can charge a fee for it. So that's generally this exception. And the content and manner exception is divided into two. The content condition is that when the rule was passed initially, there was some limitations as to the scope of the definition and the scope of electronic health information. For the first 24 months, the definition of EHI only includes the data elements that are represented in US core data for interoperability standard. And there's a list of data that you cannot block until 24 months. And after 24 months it kind of encompasses everything that is in the designated data set. So that's a content that kind of goes away within the 24 months. And then the manner, which kind of leads into fees and licensing or feasibility, is that the actor, there are different ways. If you cannot, if they ask, if the requester asks for you to provide it in specific digital format and you can, then you can use alternative manners when it's not feasible for you. So you can say it's infeasible, but I have other manners that I can provide it, so you can combine the exceptions and fulfill the request as best as you can with a different manner and condition, and rely on both of these exceptions. Okay. These are a few myths about information blocking. It says that information blocking only applies to patient requests. It doesn't. It applies to pretty much any electronic health information request from anyone. Information blocking prohibition does not apply to outpatient providers. No, it does apply to everyone. Any actor who has electronic health information must comply with this. Health information management does not have a role to play in information blocking compliance. Yes, they do. If they manage it, they have to comply. And then say information blocking changes the timeliness requirement in HIPAA. It doesn't extend it or reduce it. The timeliness requirement, it remains the same. Let's make sure. Yeah, so information has to be provided without unnecessary delay. So that still remains. It is information blocking if providers charge fees for supplying medical records, and that's not true. We have some states allow you to charge certain reasonable fees. For example, currently in DC, you can charge reasonable fees for the medical records, and you can follow whatever the HIPAA requirements and whatever your state regulations say in order for requesting fees that is not considered information blocking. The only thing is that if you have the information electronically available and you can instantly provide that to the patient, the information blocking rules require you to provide that information directly and instantly without a fee. And that would, and if you do request a fee, when you have it instantly available, that would be considered information blocking. In terms of enforcement and penalties, enforcement of the rule is generally done by Office of Inspector General under the Health and Human Services Department. Penalty is $1 million per violation based on the civil monetary penalty rules, which it applies to health IT developers and health information networks. When it comes to healthcare providers, the penalties and the process of investigation is different. OIG will refer a healthcare provider to either CMS or Office of Civil Rights, and there they're subjected to appropriate disincentives. So there's really not a dollar amount yet afforded to penalties for healthcare providers. So these are some general ways that you can start your compliance program for this information blocking rules. Go back and review your current privacy plans that you've created for your HIPAA rules, HIPAA privacy and security rules. Make sure that within the confine of those privacy, security, and privacy rules, you don't have any type of information blocking sections. You can augment those same policies to include provisions for application of the exceptions. Let's say you see a lot of adolescents or kids or I don't know, abused patients. Then you want to have some policies to make sure that you're always consistently applying, separating the documents, relying on a proper exception of harm, privacy, infeasibility, and how you're going to apply those So you can come up with some scenarios in those policies and compliance plans and procedures that you have. Define your organization's reasonable standard to assist with the audits. So, again, you got to see what, just kind of determine for you what's reasonable in terms of application of these exceptions to your system and the way that you provide electronic or medical records to your patients. If you're getting labs and diagnostics into your office, make sure that those are available to the patient as soon as the office receives them electronically, if it's feasible, if you have that type of a system. Define the situations where sensitive information cannot be hidden or redacted from the office notes. So you got to understand that if you have, Part B substance abuse notes program, Part B program notes, and your system doesn't allow you to separate those, you have to understand that all of those records have to rely on a specific infeasibility exception or privacy exception, and make sure that that is not disseminated or exchanged, and you have documentation and policies showing why, what are you relying on, and why is it that you're not producing those documents. And again, make sure that you contemporaneously document your reasoning, either that or have preconceived reasoning into your policies, so you don't have to do this on a case-by-case basis. Okay, so that brings us to the end of Information Blocking Act by the federal government. Now we're going to talk about DC medical records laws. So currently, DC patient records laws are as follows. Basically, you're supposed to, upon receiving a written request from a patient, you must furnish within a reasonable time a complete record of the copy to the patient. And you can charge a reasonable fee, and you must keep all of the records of the patient for about 3 years. That's the current state of the law. Mr. Mandelson from the DC Council has introduced the following bill called the Personal Medical Record Fee Amendment Act of 2021, and under back in March 1st of 2021, and it's now awaiting mayor's signature. So it hasn't become law yet. That the effectiveness of it is when the mayor signs it. They have gone through an introduction. The bill has to go through several other layers before it becomes a bill. So what does the new bill state? And what you are looking forward to is that there's now, instead of a reasonable time, there's a time limit that you have to provide the information to the patient, and that's 30 days. The format has to be either the format that the requester has asked for, or if you cannot give that to them, has to be in a readable electronic format. And this seems to me as though the council is trying to make sure that everybody in DC is using electronic health records. In terms of provisioning or providing electronic records, you cannot no longer, based on the new law, if it goes into effect, charge more than $6.50 for providing the electronic records. And you cannot charge per page. If you're providing non-electronic formats, 76 cents per page, and not to exceed a total of $150. You can charge for postage and handling, actual postage and handling, and you cannot charge for preparation of fees. And then the fees, which this is something that's very interesting, and it's important that the fees must be the same for patients and patient-designated persons. This is a point of, this is very interesting because there was recently, I think in a couple of years ago, a DC Court of Appeals ruling that said that at the time, I think OCR was interpreting the rules of HIPAA, saying that it all applies. Healthcare providers must treat patient requests and the fees that they charge patients the same as attorneys and insurance companies that request for patient records. And the court ruled against it and said that is not feasible. It's causing a lot of hardship for the physicians and the healthcare providers, that insurance companies and lawyers are inundating the profession with requests of medical records, and that is really too costly for the doctors. They're not in the business of providing these type of or fulfilling these type of requests to all of these requesters. So then OCR kind of changed and only applied the specific type of a fee that they requested only for patient requesting patient records. But now DC is codifying what the DC Court of Appeals said it's not good, and that is kind of interesting that they have this provision in there. The other thing that's changing is that the timeline of maintaining the record is going from 3 years to 10 years minimum, and obviously the same for minors, 10 years until the minor reaches the majority. Penalty for non-compliance under this new rule would be $25 per day if you're non-compliant, and a maximum of $5,000, and that's per case. So you can see that it could add up. So that's it. I've added some links that the AMA has a couple of really good information blocking documents that you can follow. They tell you how to start your process, how to start your program. And at this time, I can answer any questions.
Great, thank you so much. That was a wonderful presentation, and I know that I'm sure our attendees got a lot out of it. As a reminder, you can put your questions in the chat, and we can answer them here, or since we have a small enough group, if you'd like to speak up, that should be fine as well. While people are getting their questions together, I just want to note, going back to the DC legislation, that is something that MSDC is working on. There was a hearing a few weeks ago before the Committee on Health, and Dr. Alice Fuse, MSDC member, testified, as well as a representative of the medical records companies and the Trial Lawyers Association. So we're optimistic that we can work some compromise language in to that bill, but that is TBD. So, all right. Questions, anyone? All right, it is super quiet, so let me ask one of the questions that I have. We talked a little bit about who's eligible to request records, patient records. Obviously, we all know the patient can request records, but especially under the DC law and other potential changes, it expands, or kind of maybe it doesn't expand, but it allows more people to request patient records. Can you talk a little bit about some more about the things that physicians and practices need to know when getting requests from the relatives of patients, or the heirs of patients if it's a deceased patient situation? Can you touch a little bit more on that?
Yeah, of course. I mean, the same HIPAA rules generally apply. Privacy rules apply to all of those. The information blocking acts do not really make much changes to that. But it does allow for, information blocking rules are the how of production, not what to produce. So a lot of the, so if patients are requesting records, obviously they need to identify themselves, and you can provide that information to them. If patient representatives or heirs are requesting records, they have to do the proper, get the proper authorization from the patient, or have death certificate to show that the patient is no longer alive. So to that end, what is different? What is a little bit different in terms of federal law at this time is that what applies to what healthcare professionals can charge or do for patients directly is different, and those rules don't really apply to provision of medical records to attorneys or patient representatives. So they can charge more for that and do, put that more of the, just get paid more so they can stop the requests coming from the representatives, but still provide the information to the patient based under the HIPAA requirements. But what DC is doing now, they're expanding that, and they're allowing lawyers and insurance companies and all these other third parties to continuously come and ask information, and the hands of the medical professional is tied now, and they have to sort of abide by that $6.50 and 70 or $150 maximum for provision of non-electronic medical records. And that's what I think is going to cause a lot of problems and hardship for the doctors who are already, and medical professionals who are already inundated by paperwork and all the other stuff that they need to do. So I think that's a pretty interesting change that DC wants to implement.
Great question from the audience. How does any of this apply if you use paper records?
So it applies to, so information blocking generally applies to electronic health records. If you have paper records and you get a request, you have to provide that information. Now, outside of DC at this time, under federal rules, you have to provide what you have. It still applies to you if you have, the request, patient request, information request, you have to provide that information. And in the future in DC is going to require you to, under the new rule, that you provide it in electronic format. So if you don't have, if you have it in paper and they don't request it in paper, they request it in electronic and you can't provide it, you're going to have to scan it and provide it to them in electronic format. So that's how it would apply. I mean, you still cannot, under this rule, block information to give to patients because you have it in paper format.
Great. An additional question from here. What do you recommend in terms of physicians who may be closing their office in terms of record retention under these under this information? Did you have any suggestions for tips or best practice?
And they just need to keep it for 10 years. They can scan it, they can make it electronic, they can keep it in protected health record systems, but they still are required to keep it for 10 years. Or unless they can transfer it to a new entity and have them record it.
Okay, additional questions in the chat. Normally I give out my email address. I did not, and I do not see any questions in my email. So last call for questions in the chat. All right, well, hearing none, thank you much to our presenter for speaking today. I think we all learned a lot and we appreciate the information. Certainly very timely and very important part of practicing medicine in the district. So thank you very much for being here with us and for sharing some information.
Well, thank you for having me.
Absolutely. Now, I just want to remind everybody that we do have a couple of events coming up. We do have a webinar on June 8th called Fact Check Proposed Tax Changes, where the Truist Medical Specialty Team will take a closer look at potential income, estate, and capital gains tax changes. So obviously a very important topic. And then MSDC returns to in-person on July 15th with our Taking Health to New Heights program. Join us at the Yards Penthouse Pool Club, part of Vita Fitness, for an in-person event with you and your fellow MSDC members. So all members are invited to attend, and we hope to see you there in person. But if there's anything else you need from us, you know how to reach us. Thank you for joining us tonight, and everybody be safe out there.